Welcome to International Trade Minute, Quickfire Trade News. This episode is brought to you by Reidel Law Firm. Today, we bring you the most recent and significant updates in international trade, condensed into a short, concise format tailored for seasoned trade practitioners. From legislative changes and compliance issues to rulings and enforcement updates, we've got it all covered to keep you informed and ahead of the game. Let's dive into this week's headlines.
Orbit Fab has taken a notable step by urging the State Department's Directorate of Defense Trade Controls to expand a carve-out in the U.S. munitions list, specifically under USML Category 15. The company, which is renowned for developing in-space refueling systems, seeks to make it easier for U.S. companies to export spacecraft designed to refuel other ships while in orbit. The current exemption, which narrowly applies to spacecraft that dock exclusively via the NASA docking system, needs modernization, according to Orbit Fab. The firm argues that this restriction is outdated and doesn't reflect the technological advancements and increased capability in the space sector. They contend that extending this exemption to cover all cooperative docking systems would bolster U.S. and allied nations' strategic operations in space. Orbit Fab emphasizes that since the original drafting of paragraph A12, there has been a significant increase in the number of companies engaged in developing in-space fuel servicing. They note that cooperative docking systems are pivotal to this service to enhance interoperability and ensure the sustainable, uncontested use of orbital slots by partner nations. Further, Orbit Fab has proposed a clarification for cooperative docking with prepared spacecraft to be issued as a frequently asked question by the DDTC. This definition would encompass the grip and rafty architecture that Orbit Fab designs, marking a step towards standardizing a refueling interface among partnering nations. The company underscores the balance needed between safeguarding against malicious docking and promoting beneficial interoperability. Orbit Fab's initiative aims to strike this balance, thus encouraging technological growth and international collaboration in space operations. CBP's acting commissioner, Troy Miller, recently announced the suspension of multiple customs brokers from participating in the Entry Type 86 test due to significant compliance risks. This decision is part of a broader effort by Customs and Border Protection to tighten oversight and ensure adherence to compliance responsibilities. This news has sent ripples through the international trade community, impacting several firms, most notably Seco Logistics. Seco Logistics, renowned for its high compliance standards, found itself under a suspension lasting at least 3 months. The company voiced its concerns in a client note, pointing out that they had been given less than 7 days' notice and no opportunity to rectify any potential issues before the suspension took effect. Despite boasting a 99.999% compliance rate, Seco Logistics must now navigate the ramifications of this unexpected setback. The lack of transparency from CBP regarding the exact number of suspensions and the identity of the affected firms has sparked widespread speculation. While rumors suggest numbers ranging from 6 to more than 9 companies, the precise details remain unclear. However, the overarching message from CBP is unequivocal. The agency will continue to enforce strict compliance measures and hold brokers accountable for their entries under the Type 86 program. CBP's statement highlighted that brokers could be reinstated if they developed and implemented a robust remedial action plan. This point underscores the agency's willingness to work with brokers to address compliance issues, provided that concrete steps are taken to mitigate risks. The enforcement crackdown has broader implications for the de minimis threshold environment. With an increasing volume of goods entering under the $800 threshold, the risk of non-compliance, undervaluation, and even the smuggling of contraband has grown. This has prompted CBP to adopt a more vigilant stance, especially in light of recent instances where synthetic drugs like fentanyl were discovered in de minimis shipments. Industry experts, such as Customs Attorney Susan Cohn-Ross, have observed a marked increase in detention volumes at major air cargo facilities, particularly in Los Angeles. Seco's suspension is seen as a high-profile case reflecting the heightened scrutiny customs brokers are now under. The question remains as to how Seco and others will strengthen their internal controls to prevent further compliance failures. Cindy Allen, A trade compliance consultant has noted that brokers are compelled to enter the Type 86 space due to the rapid growth in e-commerce and small package shipments. However, this transition comes with inherent risks, as the expectations of accuracy and transparency in traditional retail do not translate seamlessly to the dynamic world of e-commerce. The suspensions serve as a cautionary tale for brokers, emphasizing the need for meticulous oversight and the importance of understanding the intricacies of the goods they handle. As CBP continues to reinforce compliance, the industry will need to adapt and enhance its practices to navigate this challenging environment effectively. The CBP has recently issued a customs ruling confirming that Whirlpool food waste disposers assembled in Mexico are not subject to Section 301 duties. The decision comes despite the presence of critical components sourced from China, including the motors. The ruling hinged upon the principle of substantial transformation, finding that the assembly process in Mexico effectively transforms the individual components into a new and distinct product. The food waste disposers in question comprise parts from multiple origins: the United States, Mexico, and China. Specifically, 34 unique parts go into their production, with 14 from the U.S., 12 from Mexico, and 8 from China. Notably, 45% to 49% of the cost of the finished disposers is attributed to Chinese components. Central to the CBP's decision was the extensive assembly process conducted in Mexico, which includes multiple intricate steps, such as molding, pressing, and testing. These operations are deemed sufficiently complex to change the component's original identity, resulting in the creation of a new product with a new name, character, and use. This meticulous process ensures that the motor, though originating from China, is substantially transformed during assembly. The ruling cited a 2016 court decision involving Energizer Battery to further reinforce its stance on what constitutes substantial transformation. Factors such as the number of components, the complexity of operations, and the level of skill involved in the assembly process were all considered. Despite this decision, Whirlpool has clarified that the vast majority of its food waste disposers will continue to be manufactured in Racine, Wisconsin. The units mentioned in the ruling represent an expansion into the Mexican market, rather than a shift away from U.S. production. Overall, this ruling underscores the importance of substantial transformation in determining the country of origin and the applicability of Section 301 duties for assembled products. On December 1st, the Animal and Plant Health Inspection Service, or APHIS, will commence the 7th phase of enforcing the Lacey Act import declaration requirements. This phase marks a significant expansion, covering a broader range of items compared to previous phases. In this latest round, importers will need to file declarations for all remaining plant product Harmonized Tariff Schedule, HTS codes, that are not composed entirely of composite materials. Such composite materials will be addressed in the subsequent 8th phase of enforcement. The list of items under Phase 7 is extensive and varied. It encompasses industrial or medicinal plants, plywood, laminated wood, and even items as niche as handbags, tools, matches with natural wood stems, products of natural cork, bamboo, and rattan. Additionally, other commodities like footwear and more specialized goods, such as musical instruments and their parts, fall under this enforcement phase. Essential oils, woodwind instruments, and some furniture, which were included in earlier phases, will also continue to require declarations. Specifically, APHIS has identified subheadings under numerous chapters for Phase 7 enforcement. These include, but are not limited to, chapters covering industrial or medicinal plants, vegetable plating materials, essential oils, and various articles of wood and wickerwork. Additional categories encompass articles of leather, travel goods, machinery, vehicles, and much more. It is imperative for importers to familiarize themselves with the detailed list of tariff headings and subheadings subjected to this phase. To ensure compliance and facilitate a smooth transition to the new requirements, APHIS is soliciting comments on the product coverage until July 30th. Any potential changes based on these comments will be published in the Federal Register, with industries affected by these adjustments granted at least 6 months' notice to comply with the new requirements. Importers are strongly advised to review the affected tariff provisions and prepare for the forthcoming enforcement measures. That's all for this week's episode of International Trade Minute Quickfire Trade News. Thank you for tuning in, and we hope you found these updates valuable for your practice. Don't forget to join us next week for the latest developments in international trade law. If you enjoyed today's episode, please consider sharing it with your network and leaving a review. This episode was brought to you by Reidel Law Firm, dedicated to helping your business navigate the complexities of international trade. Until next time, stay informed and stay ahead.